Now here's a couple in their early 70s. They're recently retired and lead an active lifestyle. There are some underlying medical issues, but nothing too serious. They have access to a healthy savings account, investments, Social Security, and a pension. They own their home, have 2 grown children and 5 grandchildren. They worked hard their whole life and planned for the future. Now they want to check off some boxes by addressing their legacy and make sure their estate is prepared at their time of passing.
This scenario centers on the final stages of life planning. Let's talk about that now. Jason, the final stages, what's most urgent to you in those final stages?
Well, we discussed some of the risks. They become that much more likely to occur. So the longer somebody is alive, the more likely they are to be impacted by the market, by taxes, by inflation, and then by other issues like long-term care or health concerns. So it's that much more critical that they have addressed those while they're still able to do so. And then that frees up the space so that they can think about the legacy both qualitatively and quantitatively in terms of what they want to leave behind to the people who matter to them and to the organizations.
What I find is one of the biggest issues for my clients in this age bracket is when to take their Social Security. Do they take it at age 62? Do they wait until they're age 66 and a half? Or do they wait all the way until they're 70? If they take Social Security at age 62 and they're still working, they might find that they have to repay that Social Security because they've earned too much and Social Security does a take back. If you wait until you're age 66 and a half, you can work full-time after that and not have to worry about repaying any of the Social Security. The question is also between 66 and a half and 70, if you don't take the Social Security benefits, they grow quite substantially, meaning that if you wait all the way until you're 70, your monthly benefit is going to be much more. People always wonder, but I missed those 4 years of income. That's true. The break-even point is about age 82, meaning that if you live at least until age 82, you were better off waiting until age 70 to take your Social Security. It's an individual decision. You want to look at your general health, longevity in your family to decide, do I think I'm going to beat those odds? Another question is, the IRA and the pension become mandatory distributions at age 72. That means that you must start taking minimum distributions every year once you reach age 72. Sometimes my clients might not need that money in order to fund their lifestyle. What they have an option of doing from a tax planning point of view is donating that minimum distribution amount directly from their brokerage account or whoever houses that financial money to a charity. Where typically your minimum distribution is going to be taxable income, when you choose to donate it directly to a charity, it becomes non-taxable. And if you don't need the money, and if you're going to donate to that charity anyway, it's a final hurrah to the IRS, right? You can not pay them one last time in your life and legally get away with it, I say, and give to charity.
Yes, on the legal side, there are several things. One is if you haven't done your estate planning by now, this is a really good time, to get it. There's only so many more shopping days till Christmas, so to speak. So you want to get your documents in place. The two main options are wills or trusts. So what most people don't realize is a will equals probate, namely going to court. A lot of people think, I have a will, therefore I avoid probate. Tell my clients, no, you consider a will to be a formal invitation to your heirs to go to court, okay? Going to court is good for attorneys, not so good for the beneficiaries. So how you avoid probate is you can set up a trust, living trust, we've talked about that, which is basically supersized will to make sure that your assets go to the beneficiaries that you want under the conditions that you want. A lot of people have, in this case, they've got 5 grandkids. They tend to say, well, I'm going to maybe skip over the kids and go to the grandkids. Typically that's not as good as it sounds. Most people end up changing their minds and reversing it. The other thing that's important to keep in mind are powers of attorney. So a durable power of attorney means one that will survive the person's incapacity. And so the fact that mom and dad are married doesn't automatically give them the right to make financial decisions, or more importantly at this point, medical decisions. Under HIPAA laws, you got to have that piece of paper in place to be able to access records, to be able to have input, talk to the doctors, decide, do I go this treatment or that? And so it's good to have those things in place, obviously, before you have the need. Nevada also has a very progressive thinking procedure for this. They have a lockbox with a secure site with Secretary of State that you can upload your medical power of attorney there. You'll be issued a little card that has your access information. Any doctor, hospital, medical personnel can be able to see what you have done with your medical power of attorney, which is not only during your life, but it also has end of life, what used to be living will, conditions of when do I want to have life support withdrawn, under what terms and conditions. You can lay all of this out, and what that does is it also takes a big emotional burden off of the kids who don't want to be responsible for pulling the plug on mom or dad, but if they're just following their wishes, then it's much better on everybody. So they get to say what they want and the kids don't feel guilty. So at this point in life, there's a lot of things that can be done if you haven't done it before to make sure that whatever the transition works out as smoothly as possible.